And good afternoon, everyone. I'm Chief Investigator Brendan Keefe with Atlanta News First Investigates, and you're watching Atlanta News First Plus, and we are doing continuing team coverage of the Trump indictments. We can now report that all 19 co-defendants have turned themselves in before that noon deadline today. Fani Willis had set that deadline. Technically, arrest warrants had already been issued by the grand jury, but those arrest warrants essentially weren't activated by either the judge or the district attorney to go start arresting people. They were allowed to voluntarily turn themselves in, and that resulted in them doing that. They all reached either bond agreements, or we now have one defendant who is currently held right now in detention at the Fulton County Jail, awaiting a first appearance or at least a bond hearing. So we've got a lot to catch up on today. You can hear the newsroom is full of activity right now as essentially we continue to cover this story because even though it was breaking news yesterday when Donald Trump was arrested, it is an ongoing breaking story because we have 19 co-defendants. Each of them has different court situations and unique nature of each of their defenses, and it's causing some complications in the scheduling already. But the scheduling has accelerated, and we're going to talk about what's coming next in just a moment. But first, I want to talk about one particular defendant. And that is a state senator here in Georgia who is indicted along with Donald Trump and the other co-defendants. And that state senator's name is Sean Still. Sean Still is currently a state senator here in Georgia, and he is also essentially facing these criminal charges simultaneously. To talk more about the case, I am joined now by Atlanta News First investigative reporter Rachel Polanski, who's been following the case. First off, Rachel, tell us a little bit about this state senator Still and the unique nature of what he's facing, because he's also currently a member of the General Assembly.
Yeah, so he is the only active Georgia lawmaker among these defendants. A little bit about him: he is a freshman senator from Norcross. When he's not, doing General Assembly, he works and owns a pool company in Gwinnett County. His first year in office, he served on the Education and Youth Committee as well as the Transportation Committee, two really powerful committees, as well as two others. And really the question that we were looking at is, will he be suspended during all of this, or will he remain a senator as this process plays out? And so basically what we learned is that once the governor's office received the indictment, which they confirmed to us was last Wednesday, the governor has 14 days to appoint a three-person committee that will look at Still's case and ultimately decide whether or not he should be suspended. That committee is going to be made up of Attorney General Chris Carr, a member from the House, and then a member from the Senate. Then they will have another 14 days to issue a written report basically saying whether or not they think he should be suspended, and then Governor Brian Kemp will make the ultimate decision.
So is this typical that when a lawmaker is accused of serious crimes that there is this process? Is it standard?
Yep, this is standard. There is a Georgia law in place, and the only thing that changes is if the person that is, indicted is the governor or is the lieutenant governor. It changes slightly in who makes the committee and who is a part of the committee. But this is a standard practice across the board for anyone who is indicted in the General Assembly.
And these charges, while serious, are essentially white-collar charges, and that does change things a little bit. I mean, previously there have been lawmakers accused of misdemeanor DUI or, aggravated assault, which is a felony, but this is not a violent crime. These are white-collar crimes. Does that change anything?
It doesn't appear to, looking at Georgia law. Again, I was focusing on General Assembly members convicted of felonies, so I'm not as familiar with misdemeanor
That's an important point, though. So if convicted, though, does that change the process? Because essentially there's a presumption of innocence. And State Senator Still was elected by the people. And so the reason there's this process and the reason it takes so long is because you're essentially overturning the will of the voters if you suspend somebody who elected by the people just because they're accused of a crime of which they're considered innocent till proven guilty. There's that presumption of innocence.
Exactly, exactly. And something else that's interesting about this too is that if he is suspended, well, there's two things. If he is suspended, because of an amendment that passed last year, he won't receive any pay. So the taxpayers won't be paying. And then if he is found innocent, then he will get that money in back pay.
I see. That's interesting. And what happens if he is suspended? What happens to that seat? Does it go empty, or can the governor appoint somebody to fill in his stead?
I don't know the exact details on that. We'll have to look into that, but I imagine so.
Well, it's not every day that a state senator is accused of a criminal conspiracy alleged involving a former president of the United States. It is important to point out that Senator Still was not part of the General Assembly, had not yet been elected at the time these alleged crimes occurred.
Correct. So he is a freshman lawmaker. So he began his career as a senator in 2023. So exactly that. When he allegedly was a fake elector, that was before he was in office.
So there's a minimum, essentially, of 28 days before this. So there's 14 days after the indictments.
Correct.
And then there's still another 14 days after the committee makes its decision?
Correct. And the committee can also ask Governor Kemp for an extension, so it could even go beyond that amount of time. And they also the committee could come up with a recommendation before the 14 days. That's possible too. But as far as picking the committee, by Georgia law, Governor Kemp will wait the 14 days.
I see. So that's interesting. And then the other thing, though, is Governor Kemp could overrule the committee. The committee is really a recommendation panel, right? So they can say, no, we think he should be removed, and Governor Kemp can say, no, we think he should stay, or vice versa.
Exactly. Yeah, he ultimately has the final say.
Very interesting. Anything else you think we ought to know, Rachel?
Just that, if he is suspended, that will remain either until his term runs out or until the legal process plays out. And of course, senators only serve 2-year terms, so it's likely the term could run out.
Very interesting. And that is Rachel Polanski, who is our investigative reporter with Atlanta News First Investigates. Thanks so much for joining us on that. And that does bring up the next issue, which is, how is this all going to play out? Because we have 19 individual defendants. One of them is the former president of the United States, Donald Trump, who is currently the far and away leading candidate for the GOP nomination for the next presidential election. And while the legal issues, the courts have made this very clear at this point, that his candidacy does not change in any way the court's calendar. The federal court has stated that on the record, at least in one of the 2 federal indictments that the former president is facing, is that the political calendar, while essentially running in parallel and overlaying the criminal calendar is not affected by the political calendar. Now, of course, in the court of public opinion, they're directly connected, right? And so the presidential election is November of next year. That sounds like a long time, but we're only talking about 14 months from now. I can tell you that the criminal calendar typically takes that long, or nearly that long for most big cases, and sometimes even longer. And one of the classic techniques of defense, whether you're innocent or you're guilty, when you're defending against criminal charges, one of the classic techniques is delay. The reason delay is your friend if you're accused of a crime, again, whether you did it or not, is that witnesses' memories tend to fade. Witnesses sometimes are no longer with us and die of natural causes. This sounds harsh, but this is the cold reality of criminal defense. And then the other thing that happens is, delay might lead to a better situation down the road. And it also tends to wear down the prosecution to where they might abandon some of the charges. They might reach some sort of a plea agreement, depending on which defendant you are. So this is why delay is a classic tactic. It's very rare for a defendant to invoke the speedy trial demand, but that's exactly what happened with Kenneth Chesebro. And so you're saying, why keep hearing about this Kenneth Chesebro? We actually don't know if it's pronounced Chesebro or Cheesebro. We've heard both. He's an attorney from Wisconsin. This is his photograph. That's not the mugshot. This is his sort of, standard photograph. But he was an attorney. He was involved with the so-called fake electors plot the side of the Donald Trump and his alleged co-conspirators would argue that it was not fake electors, but rather sort of provisional electors should he have prevailed in court. But at any rate, that's where he's charged. He invoked the speedy trial demand. And this set off a flurry of motions yesterday. Usually court moves at the speed of government or even slower. So we see motions and then counter motions over weeks and months. In this case yesterday, we saw motions and then and the day before, and then a judge's decision almost immediately. So here's what happened. Let's lay it out for you real quick, and here's why it affects the Trump case. First, you have Kenneth Chesebro file this motion for a speedy trial. That invokes this Georgia law that says basically it has to happen within 2 court terms, which sounds like a long time, but it really isn't. And so basically that put pressure on Fani Willis to have to prosecute this case within essentially 60 days, that go to trial within 60 days, roughly. And she said, and by the way, the reason you file a speedy trial motion typically is because you don't think that the prosecutor is ready. You know, when they bring indictments through a grand jury, that is a much lower standard of proof than beyond a reasonable doubt. It's just probable cause. It's really low on the standards of proof. And so it doesn't take that much actually to get a grand jury indictment. It's more than reasonable suspicion. It's less than preponderance of the evidence. It's probable cause. We think they did this. And so there's this indictment. Beyond a reasonable doubt is a much higher standard. And when you file the speedy trial motion, you're basically saying we don't think the district attorney can put together a beyond a reasonable doubt prosecution within that reasonable or within that amount of time for a speedy trial. So I called it yesterday freezing the kicker. It's like, you know, the field goal kicker is about to kick the game-winning 3-point field goal, and right before the kicker hits the ball, you call a timeout. That's kind of what this is from a procedural standpoint, because it puts all the pressure on the district attorney. It's basically put up or shut up on the evidence. And what happened, though, is DA Fani Willis responded with, okay, let's go to trial. We're all in favor of the speedy trial. In fact, we want to bring all 19 defendants to trial in 60 days. That was another bold move. So the speedy trial demand's a bold move, and then DA Fani Willis it's like three-dimensional chess, right? She says, all right, we're ready to go to trial right now with all 19 co-defendants. Well, the other 18 co-defendants were saying, wait, hold on, pump the brakes. We're not ready to go to trial. And immediately Donald Trump's new legal counsel filed motions to say, no, actually, we want to be severed from Chesebro's case, and we're going to file motions to do that. But first and foremost, we are not ready to go to trial in 60 days, so we don't want to have anything to do with that. So what happened was Judge McAfee issued a ruling yesterday, like immediately. This was an incredibly fast ruling. And actually set the trial calendar for Kenneth Chesebro. He said it's only for Kenneth Chesebro, which effectively severs him from the other 18 defendants. But this really aggressive trial calendar is set for October 23rd. So you're like, October 23rd, that's 60 days. It's now 59 days from today that we're talking about going to trial, at least in his case. And it's a very aggressive trial calendar, but you have to put yourself in the shoes of the judge sitting on the bench. When you have a motion saying speedy trial, and that, by the way, is a very serious motion in Georgia, because it's basically you're entitled to a whole bunch of rights at that point as a defendant, because they clear the trial calendar to make sure you can get that speedy trial. And then you have what would have been an opposing motion, but no, it's a motion essentially saying, yeah, from the district attorney, let's go to trial. So these are the two sides. If you're the judge in the middle of, yeah, let's go to trial, and yeah, we're ready to go to trial, the judge really it's hard for the judge to make a decision when both opposing sides are in agreement, essentially. So the judge said, okay, fine, here's the trial calendar. Let's do it. Now, the defendant, any defendant, is entitled to a fulsome defense, and part of that is preparing. And it may seem boring, but it's really important now. There's all of these pretrial motions. There's discovery, which is discovery is simply the rules that govern getting evidence from both sides. So everyone has to kind of show their cards. And then there's also what's called Brady material, which is from a case called Brady, where the defendant is entitled to see anything that might be exculpatory. So if the prosecution can't hold back evidence until trial, that might clear the defendant. And that's kind of important, that you're not only able to get that, but you're able to review it and then formulate a defense. So it's very possible that Kenneth Chesebro and his attorneys may actually withdraw their speedy trial motion because if, and we don't know if this was why it was filed, but if it was filed in order to sort of throw off the district attorney and it didn't work, they may decide they want more time and they can withdraw that. You're basically saying to the court, we've changed our mind, and judges don't like when you start messing with their calendar, but the defendant is entirely entitled to do that. So here's the other big issue. Why do we care about this? Is because it's accelerated the trial calendar to where two things happen. One, Fani Willis has to get her case together, at least a mini version of it, and be ready to try it on October 23rd. That would be the day the jury selection would start. But also it would give a preview to the other co-defendants. I mean, if you're Donald Trump's counsel, I made this point yesterday, it's sort of like going to if you're a college football coach or quarterback, going to the game the week before and watching how they play another team, you kind of get to see their playbook. So this would be like a preview for Donald Trump and the other co-defendants to see what does Fani Willis have, but also more importantly, how is she going to present it, and what's her sort of prosecutorial tactics here so we can defend against that. So in that case, it kind of helps the other co-defendants so long as their trials are later, and it kind of puts pressure on Fani Willis to get her case together. Fani Willis seems to be like, hey, look, we've been investigating this for 2.5 years. We already have all the evidence we're ready to go forward. So here's what complicates everything. And you're like, oh, wait, this is turning into a law school class, and Brendan doesn't even have a JD to be able to teach this. But here's why this is absolutely fascinating from a procedural standpoint that actually affects why everyone should care. Essentially, we have so far a couple of defendants, and we expect Donald Trump to join them, going to federal court here in the Northern District of Georgia and asking a federal judge to remove the case. Mark Meadows is one of them, the former White House chief of staff, saying, let's remove this to federal court. Now, I don't want to bore you with all the details because you're saying, wait, this is a state case, this is a Fulton County case, why would it go to federal court? Their argument is that they were federal officers, that Mark Meadows was serving as the White House chief of staff at the time, and everything he did was at the direction of the then president of the United States, so this would come into this sort of under the color of his federal officer position. So he didn't do these things as a private citizen, he did them as a federal official, and therefore he's entitled under federal statute to remove these state charges to federal court. Why it matters is because, and by the way, a lot of people are getting this wrong. This doesn't mean that now federal pardons are in play. There's still state charges, and if there are convictions in federal court, they would be under Georgia law. And the Constitution does not allow, it only calls for pardons for any offense that is brought by the United States of America, not by state charges. So this doesn't invoke any kind of opportunity for a pardon for anybody. What it does do, though, is it puts it in front of a federal judge under federal rules and the federal court rules, even though it's a state charge. Fani Willis and her assistant DAs would actually prosecute the case in federal court, but under state law. So again, it's really complicated, but here's the big issue for Donald Trump in particular and his co-defendants as well, is that if this gets removed to federal court, and it's possible all the cases get moved to federal court, because if one goes, if they say, Mark Meadows, yeah, you were a federal officer, the co-defendants can say, look, this is a RICO conspiracy case, it's all tied together, we need to be tried in federal court too, even if we weren't federal officers. David Schaefer's filed, for example, he was the GOP chair in Georgia, and he's filed because he said, I was an elector, and as an elector for Donald Trump, I was essentially a part-time quasi-federal officer. Whether or not that's a stretch of an argument, all the defendants could end up in federal court if the court agrees with this. And here's the big issue, is that it would open up the jury pool to not just Fulton County, which is very diverse politically and socioeconomically, racially. It would open it up to a much broader swath of the Northern District. So you'd bring in areas like Cherokee County, which went overwhelmingly for Donald Trump, where Fulton County went for Joe Biden. So you'd have a much broader and more, frankly, more conservative jury pool, and that's the jury pool for these state charges in federal court if that happens. So you're saying, okay, what's next, Brendan? This is all really academic and interesting, but what's really going to happen next? What's going to happen next is Monday. there is going to be a hearing in federal court in the Northern District of Georgia in front of a federal judge where Mark Meadows and his attorneys are going to be able to argue for this removal. No matter who prevails, no matter what the judge decides, and by the way, it shouldn't matter, but it's an Obama-appointed judge versus a Kemp-appointed judge in state court, which complicates matters a little bit, because do you want to stay, if you're Donald Trump and his co-defendants, do you want to stay with the Kemp-appointed, more conservative, though respected judge in state court in Fulton County, or do you want to go with the Obama-appointed judge in federal court? Again, it shouldn't matter, but it's part of the calculus. No matter who prevails in that Monday hearing when the judge finally rules on removal, they're going to appeal. And the appeal, because it's a federal motion, is going to be to the 11th Circuit U.S. Court of Appeals, which is here in Atlanta. It's basically one stop before the U.S. Supreme Court. And again, not to turn this into a law school class, but under state charges when you appeal to the Georgia Appeals Court. So if you have any issue that arises in Fulton County and you don't like the outcome, you get to go to the Appeals Court of Georgia, and then the next appeal is to the Georgia Supreme Court. In federal court here, we're in the 11th Circuit, which includes it's Georgia, Alabama, and Florida. You appeal to the 11th Circuit U.S. Court of Appeals. That's a very conservative appeals court here in Atlanta. And so no matter who prevails on this withdrawal motion, it's going to go before, it's definitely going to be appealed to the 11th Circuit U.S. Court of Appeals. It's just, it's automatic that whoever loses is going to go and appeal that. And then no matter what the 11th Circuit rules, you have the option to appeal to the Supreme Court of the United States. Now, the Supreme Court of the United States doesn't have to hear the case. They grant something called cert. It's short for a longer Latin name, certiorari, basically means granting the ability to hear the case. And the Supreme Court picks and chooses which cases it hears. But a case involving a former president of the United States is likely to be granted cert, at least on an emergency basis. They may hear this removal case. So this little case, and I don't mean to call it that, but compared to the U.S. Supreme Court, this little case in Fulton County, Georgia, might end up in front of the U.S. Supreme Court sooner than later in terms of if there is a removal to federal court and Fani Willis wants to appeal it all the way up there, or if there's no removal and Donald Trump wants to take it to a Supreme Court where he's appointed several justices, does he want to go and make that argument? So we have some really interesting procedural things that are going to happen in the next several days, really. I mean, this is going to happen really quickly. The next thing that's going to happen is the week of September 4th. Starting on September 5th is when Fani Willis, that's a Tuesday, when she wants to hear these arraignments. That would be in front of Judge McAfee unless a removal occurs for one or more defendants. The arraignment is simply a reading of the charges in front of the defendant or defendants, and would be read by Judge McAfee, and then there would be an enter of a plea. The judge would say, how do you plead? Are you not guilty or are you guilty? And we expect a bunch of not guilty pleas, and then that starts the trial process. And the trial process doesn't happen immediately. As we said, it can take weeks and months and sometimes years. We don't expect it to take years. We do expect it to take months, but at this point we have that accelerated schedule for one of the co-defendants, Kenneth Chesborough. So we now have all of the mugshots. These are, and by the way, mugshot is the colloquial term. Donald Trump last night said that he had not heard the term before when he was at Wharton Business School, when he was on an interview with another news outlet. But they're actually technically called booking photos. And the reason they're called booking photos is this is when you're booked into the jail, they take your picture. You probably can tell, and it's interesting that this is the first time we have all of these on the screen at the same time. So this is the first time we're seeing all 19 co-defendants in their booking photos at the same time. You'll notice, you remember that game, in the highlights book in elementary school where they'd ask you to pick out the things that don't belong or that look different? You can see, we've got a couple of these mugshots or these booking photos that kind of stick out a little bit. And the reason is the Fulton County Sheriff's Office clearly improved their camera and lighting as this went on. I was the first to kind of criticize how it was sort of overblown in terms of the lighting. You can see, like David Schaefer, like half his face there's no detail in it. They clearly fixed some of the lighting, anticipating, the former president, the 45th president of the United States showing up. So you can see, for example, Donald Trump's lighting is a lot better than, say, David Schaefer's lighting. Similarly, John Eastman, he's second row down from the top, second from the left. So he's next to Rudy Giuliani, and he's under the former White House chief of staff, who's above him. You can see how his forehead's kind of blown out there. And look, this doesn't amount to anything except it's pretty clear that the Fulton County Sheriff's Office, which said they were going to treat everybody like, the same as any other criminal defendant, clearly worked on their photography and lighting skills as the week went on and people started to turn themselves in. Jenna Ellis is the only one smiling in that frame. That's sort of the, at least a full smile. That's, well, no, actually, we do have another smiling photo. Sorry about that. I'm not wearing my glasses here. And that's the former PR person for Kanye West there, who's accused of trying to persuade Shay Moss and her mother to sort of change their story, or at least that's the accusation. So we do have two smiles, and it's sort of just a I guess, tactic, or however you want to say it, is trying to turn it into more of a yearbook photo. There's been a lot of talk, and I'm not going to add to all of the criticism of Donald Trump's sort of view. Somebody pointed out on CNN this morning. They said it's like a political Rorschach test. Some people see it as defiant, others see it as a scowl. Some see it as a we're going to defend this strongly, whatever it is. But there clearly was a strategic decision to have a certain expression for the former president, Donald Trump. And here's some video of how the motorcade showed up. Some things were done a little differently. And by the way, look, given the seriousness of the charges, it's not worth talking about the trivial sort of debate over the height and weight that was reported. But it is worth noting only in so much as people have said that a lot of this case is about the truth and the former president's relationship with the truth. And he self-reported, or his team self-reported, a height of 6'1" and a weight of 215. And, many people have questioned that, especially given that, Rudy Giuliani was listed as much heavier, even though he's shorter. I mean, look, that's all trivial, and it's sort of palace intrigue to talk about. But the only way it relates to the case is that this is a case about, an election that wasn't stolen, that it was reported, by the former president as a fraudulent election that he was trying to reverse. And that really is the whole case, right? I mean, the whole case comes down to whom do you believe, who is telling the truth. But it also comes down to criminal intent. And so the prevailing defense that's expected is John Trump, former president, is going to say, when I was president, I believed the election was stolen. And if he truly believed the election was stolen and was trying to, right the wrong, then there's no crime because there's no criminal intent. He was just, trying to fix the broken election. There's a few things that fly in the face of that. For example, his own Attorney General, Bill Barr, was saying, no, the election wasn't, we're finding no evidence of that. And then you have the call to Brad Raffensperger of, I just need to find 11,780 votes. It would be different if he said to Brad Raffensperger, if then President Trump said, this election was stolen, and in parts of the call he does say this, you guys got it wrong, I need you to right the wrong. But instead he said, I need you to find, or I just need to find, he said. He didn't say, I need you to find. He said, I need to find 11,780 votes. That's a very specific number because it was one more vote than Joe Biden was at the time leading the state. And the election had been certified. There had been recounts. There had been a hand recount. There had been court challenges. And so all of those things are going to matter. But the last thing I want to say before we wrap up, and we're going to be on, by the way, with continuing coverage all day, particularly on AtlantaNewsFirst.com and later, really starting at 3 o'clock on Atlanta News First and on Peachtree TV. But the last thing I want to mention is I was talking to a defense attorney earlier today. It's Josh Schiffer, who you've seen on Atlanta News First Plus. And he basically said, as a defense attorney, any of these defense attorneys has to do is find 2 jurors that they can sort of separate out from the rest of the jurors. If this does go to jury trials, and some of them are almost certainly going to go to a jury trial, all you have to do, because it has to be a unanimous, beyond a reasonable doubt verdict in order to convict, you just have to find really 1 juror who disagrees, and the strategy is to find 2. So if you find 2 whom you can convince, and they might already be part of the jury pool. I mean, look at the way our nation is split. There are some people who are absolutely convinced Donald J. Trump broke the law, and then there's others who are absolutely convinced he couldn't possibly have broken the law. And so if you get a jury with that split, how do you get a unanimous verdict? How, when we're arguing, as a nation, do we get a jury that isn't arguing in the jury room? And and if you don't have that diversity on the jury, then you don't have a fair trial for either side, because you don't want a jury of 12 people who all think one way either. So that's where the dynamics of this are really going to, break down. And then the final thing is that this could be tied up in appeals. It almost certainly will be for a very long time. If anyone is convicted, they have the right of appeal. Any U.S. citizen does. And that can drag out for years and years. And that's where this is going to get fascinating. And one more final thing, because I promised a bunch of final things, or one final thing, and now here's the third. But it needs to be said again. A conviction does not preclude Donald Trump from running for president in next year, or right now. If he's convicted before the election, it does not preclude him from being elected, and it does not preclude him from serving. There is nothing in the U.S. Constitution or the U.S. law that prohibits someone convicted of even felonies from being elected or serving. That trust is placed in the people, and the people will have to decide at the ballot box if they want someone who's convicted or accused of felonies to be their president of the United States. And with that, I'll wrap up. I'm Chief Investigative Reporter Brendan Keefe, and this is continuing coverage of the Trump indictments and arrest here on Atlanta News First Plus. Have a great day.